I can't imagine me or any other judge throwing out a case on the basis that they should have administered a blood draw as opposed to a breathalyzer if the officer was told and the court believes that it's truthful testimony that the defendant told the officer he's not diabetic. I can't imagine me throwing out a case saying, oh, it's a miscarriage of justice. He should have been a mind reader. He should have been Houdini. He should have been a read everything. All right. People against Norbert Pastor, 25T644584. Good morning, Mr. Clovis. Your appearance?
Bill Clovis, P3434, I'm the defendant.
Mr. Pastor?
The defendant here. Oh, here it is.
Your name, sir?
Good morning, Woodruff, Pastor.
Okay, Mr. Bologna?
Anthony Bologna, City Attorney.
So you want to argue your motion now?
Sure.
I don't need to hear about the one with, how do I say this? I'm not, I would not have scheduled this for hearing at all if it was still over the motion to withdraw the plea.
It was a motion to withdraw, the plea was denied.
Correct.
It's a motion for reconsideration.
But you filed a motion for reconsideration. I didn't know that you were asking for a Ginther hearing before. You mentioned something about ineffective assistance and
Right.
go ahead. Why don't you proceed?
We would like a Ginther hearing concerning this because on October 7th of last year, Bobbins's being represented by the prior attorney. He had a medical consultation quite in depth, and it does show the diabetes he suffered from. And I guess ultimately is this, they're claiming by hearsay police report that he said he wasn't a diabetic when asked on the road or I don't know where that they allege. Even if that was true, we deny it, but even if it was true, it's a manifest injustice that he pled guilty, that it was artificially high, his blood alcohol level. So in other words, if DNA is somebody's convicted of murder, great, and DNA later shows something, well, you know what? It's not a manifest injustice. I understand that that's an.
You have a medical record that tells me, a doctor that tells me that he's a diabetic?
Yes, Your Honor.
Is it saying a report or am I going to be asked to interpret numbers here?
No. That he's a pre-diabetic. And Your Honor, I'm a pre-diabetic and I have to take a shot and 3 pills every day. So I don't know where they come up with the word pre, but they called me that too. I guess after a certain number, you become a diabetic officially. But I take Ozempic and I take 3 other pills for my pre-diabetes.
I know, but a lot of people take Ozempic just because they want to lose weight too.
It ain't losing weight. Mine was almost going into shock when I was in Chicago about 2 years ago.
Well, if this is a report dated October the 7th,
Right.
what is this medication that he's on?
What kind of medication?
Metformin.
For what?
Metformin.
What's that for?
Diabetes. I'm on 1,000 milligrams daily for the last 2 years. We had produced last time the prescription history from Myers.
Have you seen this, Mr. Bologna?
I have not yet.
The pre-diabetes. That doesn't mean he's a diabetic though, right?
Your Honor, I'm a pre-diabetic and I have to take the shot
Why would he have told the police officer he wasn't diabetic?
first. It's a police report hearsay. Nobody's testified to that. And the bottom line is, Judge, respectfully, if they're inaccurate results, that's a miscarriage of justice. If they're they can't do that test.
Well, wait a minute. You mean I could, if I'm diabetic, I could tell them I'm not diabetic, have them lure them into giving me an intoxilizer and then come back and argue that the intoxilizer results are invalid because you bought my lie and you relied on it and you didn't get a blood draw instead?
Judge, I doubt very much that he knew scientifically that he can't take the breathalyzer. His attorney didn't know, and it was never brought up at all.
Because why would a lawyer bring it up when their client told the officer they weren't diabetic?
Your Honor, that's hearsay right now.
All right.
You're relying 100% that the officer said that.
Well, who are you relying on? You're handing me a police report you're handing me a medical report that says pre-diabetic. You say he's a diabetic, he says he's a diabetic now, even though apparently he told the police. So the police are either lying in a police report, in which case they should be kicked off the force.
Okay.
Who's saying he's a diabetic? This says pre-diabetes. What information do you have to tell me that the lawyer should have pursued that?
Pre-diabetic is like diabetic. That's what I am.
Well, you're saying that. I don't know that to be true.
Making it up.
Well, I don't know if you are or not.
Oh, there you go. Okay.
Well, you guys are coming in now saying there's diabetes involved, and I don't have any evidence of that.
You got it in front of you right now.
It says pre-diabetic.
Uh,
What do you have to say, Mr. Bologna?
Your Honor, if the request is for a Ginther hearing at this point, it's focused on ineffective assistance of counsel. All we have to work off is what we have in the report and what was done up until now. The report says that he stated he was not diabetic. So the question is, was there ineffective assistance of counsel? The counsel is reviewing that report. I can only assume that he's not going to ask me follow-up questions as it relates to diabetes. So unless there's something that states where the client presented prior counsel with a statement saying I'm diabetic or medical records to prior counsel stating that he's diabetic, I think it's safe to assume that there was effective assistance of counsel in this whole process.
His prior counsel didn't even know what diabetes does or pre-diabetes.
Who said that?
Hearing, I'll have a doctor sitting up there during the Gunther hearing and the former attorney. The results are just, they're void. We can't say, well, you said something to the officer, so we're gonna put everything aside.
Okay, so I just want to ask you this question. If the officer comes in here and tells me, Judge, unequivocally, the defendant told me he was not diabetic. How, and if I believe that officer's testimony, you still think it's ineffective assistance of counsel because the defense lawyer didn't pursue an avenue when the officer had been told by the defendant, according to the officer, that he was not diabetic, and therefore that the defense simply could lure somebody in by saying, no, I'm not diabetic, wink, wink, and then go back and say, I was diabetic and the results are skewed. I can't even imagine a lawyer trying to argue that his client's diabetic if the officer was told by the defendant, if the officer was told by that, you're right, there are mistakes, that he was not diabetic.
He's got medication with it. And it's on the report, his medication.
Which report? The medical report or the police report?
I believe both. I'm medication.
I didn't ask you that. What report are you referring to? The medical?
That report
The
has,
medical report.
and I'm sure the inventory, and I don't have the inventory report, has what was on it. I don't have an inventory report. I don't.
What else? Anybody else want to help me out here and tell me why I'm thinking incorrectly? Mr. Bologna, Mr. Colovis?
A hearing would resolve, so it would be a very short hearing.
You're gonna bring in the doctor.
I'll bring in his treating physician, not a made up one. And how long he's been on it. So what I'm saying is, let's just say that the officer heard that my client was not a diabetic. Let's just say, does that mean that test results go in? Absolutely not. You gotta lay foundation. And one of the foundations is, if you're diabetic and you blow.
If you're conceding that he told the officer he was not diabetic, are you conceding that?
No, I'm saying what, the worst case scenario, that's. I haven't seen a video, I haven't seen it.
I can't imagine me or any other judge throwing out a case on the basis that they should have administered a blood draw as opposed to a breathalyzer if the officer was told and the court believes that it's truthful testimony that the defendant told the officer he's not diabetic. I can't imagine me throwing out a case saying, oh, it's a miscarriage of justice. He should have been a mind reader. He should have been Houdini. He should have been a read everything.
Nobody says throw it up. What we're saying is those results, if all true, the breathalyzer results are excluded. And now they can try their case the old fashioned way.
Well, that's what I meant, throw out the results.
Correct. That's like not watching a person for 15 minutes, they regurgitate and then they blow.
No, that's a lot different than somebody telling an officer I'm not diabetic and for the officer, well, I'm gonna pretend you are. I'm gonna pretend everybody's diabetic because they could be lying to me. They could be luring me in. I'll give you your hearing, but I hope you're not wasting the court's time.
I will.
You subpoena the officer, Mr. Bologna. I know you said at one point he doesn't work for the department. I want that officer here. And I want to hear testimony. But I can tell you, honestly, Mr. Kolovis, I can't imagine any judge worth 13 cents throwing out a breathalyzer because they administered a breathalyzer to a diabetic who happened to tell them that they weren't diabetic.
So if the breathalyzer was not working properly,
Did you hear what I said?
you leave the results in.
If I administered a breathalyzer because the defendant told me he was not diabetic, yes, I would.
He also told him he wasn't drunk. It was for that.
Come on. I'm not going to argue about it with you. I'm just telling you. I have a feeling there's more to this, but I'll listen to it. We'll have a hearing. When are we going to do the hearing? I want to do this quickly.
Yes.
How do you want to do it? 2 weeks, Judge, or how?
Yes, May 7th.
May 7th, you want to do 11 o'clock?
Can we do it later in the morning? Because I'm in Ann Arbor again. That's where I was this morning. I have to drive right back there.
All right, let's do May 7th. Yeah, 11 o'clock.
Can we do what? What is it? Lunch? One. What?
You're going to subpoena.
May 2nd to May 10th, the family is on vacation.
To where?
For what? Why don't you tell the court?
They're going down to Florida for conference.
I can't hear you.
I'm sorry. I needed to request a time between May 2nd to the May 10th. I tried to voice.
You got to keep your voice up.
I'm sorry, sir. I needed to request time to the May 2nd to the May 10th.
There's a medical conference.
I go and meet like two of my doctors for it. I'm sorry about that.
Let's.
You want to do it before then?
You going to be able to get somebody here before then, Mr. Bologna?
I have no clue on the officer's availability here, so I'll try my best.
What days?
Why don't you go call him real quick? See if you can get a hold of him.
I'll see.
Because I don't want to put this off to the 21st. I really don't. Can you,
Thinking next Thursday?
if everybody's available, that's exactly what I'm thinking.
Your Honor, too.
That's April 30th, right?
Yes. Being that this is a Ginther hearing, though, the hearing is to determine an effective assistance of counsel. Concern is we're gonna get into the weeds and create some type of record now as it relates to evidence that wasn't even put forth before this court in consideration of how we got here.
That's the effective assistance of counsel.
Well, my view is should be more focused on, did counsel even know about this diabetes? Is there any evidence that counsel was aware? of. his
Well, of course, that's all part of it.
I guess we'll find out.
They have to prove essentially that the defendant is diabetic. It was conveyed to defense counsel. Defense counsel didn't pursue any kind of defense, period. That's generally speaking, but that's what they're going to have to prove. I think your point in your brief is well taken. Why I'm so frustrated is because I just can't imagine somebody, a lawyer, reading in a police report that his client admitted that he was not diabetic, or at least told the police he was not diabetic, and then faulting the lawyer for not pursuing a claim that the intoxilizer or breathalyzer shouldn't have been administered because he's a diabetic. I can't imagine it. I can't imagine somebody lying to the police about whether or not they're a diabetic. And even if he wanted to come in and claim that he was diabetic, if the officer's testimony is to be believed, let me be clear about this. How am I going to find that there's ineffective assistance of counsel? That being said, let's figure out what day we're going to do it. I will honor your client's ability to leave the state between May the 2nd and May the 10th.
How about 4/29 as well? Next Thursday.
I'll tell you what, I'll make it. Am I good that time, Heather?
On which date, Judge?
April 29th at 11.
Let me look at our docket.
Is that the 29th?
It's a Wednesday.
That's a
Oh,
That's a
Wednesday.
Wednesday.
Let me just check something. The
30th is what I thought.
Yeah. Are you good at 11 on that day?
But, yeah,
Well, you're here with Judge Hessen though.
I'll be here.
Why don't we
You-
do it at,
We can
You
it.
do have a trial at 11 on the 30th,
what kind?
a domestic violence.
Let's do it at 1 on the 30th.
That'd be perfect.
Now, here's the thing though. If either one of you can't get your officer here, can't get the doctor here, then we're going to have to adjourn it. So you guys can be big boys and figure out a time with my judicial clerk, okay?
That's great.
April 30th at 1, okay?
Thanks. sir.
Thank you. People against Michael Reban. 26G 306-836A and B.
Morning, Your Honor. Attorney Ryan Rains, sir, PSAP 3195, and we have this degree of understanding.
Is this really going to go to trial?
Your Honor, unfortunately, my client is a CDL driver whose job was riding on this. We would seek time to hire an expert. There are some issues with the MSP lab results that I did get back in that we do think is a potential tribal issue as well.
Calling the prosecutor. This is Gibraltar, Mr. Bologna. So that's fine. I don't have a problem. I'm not going to adjourn it that long though. We're going to have to set it real quick. This case was arraigned on February 26th. So it's 2 months old already. So let me get this, what do you have, Heather? Look for a date about a month out. Can you do that for me, please?
A month out for Gibraltar.
Correct. For a jury trial. Mr. Bologna, your name?
That's.
All right, we're gonna set a jury trial date, and I want to make sure everybody's agreeable with it. Absolutely.
So our 4-week out date, Judge, is the 21st.
May
That's out of-
21st?
If you're looking for a Gibraltar date, that's
No,
our
no,
4 weeks.
No, I need a
Or do you
jury
want to do a
trial
Friday?
date.
Oh, wait, so you want a Friday, I'm sorry. So that will be the 22nd.
That's Memorial Day weekend.
It is.
Yeah, we don't want to go that long. I don't want to do it Friday.
You want to do
before.
the 29th then?
If they can do it on the 29th, great. If not, I'm gonna make it May 15th. Not going
Of course, I
to,
cannot on the 29th, I have to be in Oklahoma. The softball down there, but I could do it on 15.
I'm unavailable on the 15th, Your Honor.
why didn't you just tell me before if you're gonna set this for trial? I would have said it a long time ago. I thought,
We were trying to work something out. I got into the MSP records, and like I said, there's a potential issue there, but it's not enough for Mr. Bologna to have an offer. And of course, Your Honor,
June 5th. June 5th, how's June 5th?
That works for you.
Let me look at the calendar and see what.
Oh, wait a minute, I'm not here.
So, like I said, the only potential with that one, I can go to June fourth and.
See, hang on a second. I'm not here that. I just wish you would have told me before. I could have said it and then we wouldn't be going through this. If you knew you were gonna try the case, he's got CDL holding. I wish you would have told me.
Absolutely.
June 12th? Am I here, Heather? No, I'm not. So this is.
No, you're not,
Your
Judge.
problems become my problems now.
And then the 19th, we're closed.
So I'm not going to the end of June. So we're gonna have to find a Monday. You go down the hall and talk to her. Pull out a Monday for me, if you will, Heather. I'm not going to end of June or early July. I'm not doing that. So we're gonna have to,
You wanna-
find a date in May that is on a Monday or a Thursday or another day. And if I have to cancel a Trenton docket, I'll do it. So why don't you look at that?
So I don't want to do our May 21st because that's our add-on Brownstown docket too.
June
That would be a
1st.
Thursday.
What about
June
June
1st,
1st?
you have a civil docket.
We'll cancel.
Your Honor, again, I'm gonna be in Oklahoma.
You guys, I wish you would have told, why didn't you just tell me this, Mr. Ramsey? I would have been glad to accommodate, but we could have set this 2 months ago and then we wouldn't have this problem.
Apologize for me.
So
Judge,
now. I
June
mean,
8th, June
go
8th,
ahead.
you have probation department rep, so I don't know if you want to keep it light that day and then.
Yeah,
you
we
could
can do
start
that. How
your
about
trial
June 8th?
after-
June 8th works for me.
Okay, let's do the June 8th date. We'll make it at 9 o'clock, June 8th to 26th at 9 a.m. Now, listen, you guys are gonna give me the jury instructions, and I'm gonna hope that you agree on them. If you don't, well, you can argue them, but I want the jury instructions due by. What day you get back from Oklahoma?
I come back on May second, I'll be back at work on the fifth.
June 2nd. you mean.
Daniel,
When are you going?
I'm going, it's the 28th of May through June
Well,
second.
then let's make them do May 26th because,
Understood.
but you guys have to give them to me so I can just read them. You know, you got everything filled out, right? All the offenses, all the instructions, but
Complete instructions, Your Honor.
complete instructions. So I'm Judge McNally and you are so-and-so. You can put it in everything, okay? By May 26th, June 8th, you guys, will it help to do a final pretrial or not?
I was gonna say, just in case, if we could have a final pre in.
Well, what do you want to do, a final pretrial then? May 21?
Yes, Judge, we could do
21
May
would be fine.
21st.
Yeah, we're here, Your Honor.
At what time?
If we could
I do
10,
10:30?
That'll work.
Yeah, that's fine. We'll do May 21 at 10:30. Okay?
Thanks, Judge.
Thank you very much.
Thanks a lot, you guys. Have a good day. Good luck, Mr. Reban. Missile Brandon Christopher Missile 260-647-450, A and B and C. Did you have a lawyer, Mr. Missile?
No.
Did you talk to the prosecutor?
No,
How long you been here?
it's 9 o'clock.
Where were you seated at? You didn't check in with my court officer?
No, he told me to just write on the pad of paper outside of the door and wait for someone to call me. And my mom's been sitting out there with me, she was like to go to work.
I feel bad for you. Come on up here. Come on up here. I'm sorry. 260-647-450, A and B and C. Your name?
Christopher McCullough.
You live in Flat Rock, right?
Yes.
So I'm ready to start another case with the prosecutor here. Do you mind if I reschedule this or
No, that's fine.
are you sure?
Yeah.
I am so sorry that happened. So you signed out there somewhere?
The pad of paper outside of they said go to the door 3, courtroom, or prosecutor 3, and sign that yellow pad of paper. My name, I signed my name on there. I said, just wait for the prosecutor to come out here and call it.
And the prosecutor never called him?
Brandt's up front subbing, so he gave him some bad information.
Okay,
He never
okay.
checked.
I got it. I am so sorry about this. Well, Just been a little,
Yeah.
is May 7th okay for you?
It should be, yeah, really any day it's gonna have to be okay.
Well, I mean, you've been inconvenienced. If you want me to make it May 7th, I either have May 7th or May 21st for you. Wherever you want,
Yeah, you said the 7th or the,
or the 21st.
or you want to do the 21st?
Absolutely.
Oh,
My apologies.
that's all right.
Now, next time when you come here, we'll make it at 9 o'clock. You just come in and check in with my court officer. You fill out an advice of rights. And then you can tell him whether or not you want a lawyer. If you want a defense lawyer to help you, we'll set you up with one right then. Okay?
Thank you so much.
All right. Sorry about that. I truly am. Tilly?
Ready?
Tyler, Tillery? 260-306-839 A and B.
Good morning, Your Honor. For the record, James Schlock, 30720.
All right. This is just an arraignment, right?
Yes, he waives the formal reading of the information and stands mute.
I'll enter a not guilty plea for you, Mr. Tillery. Can you tell me your name, please? You have 3 charges: super drunk, violation of restrictions on license, and you also have the civil infraction of refused PBT. I'll enter not guilty pleas. I'm going to give you on the misdemeanors, $1,000 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. So he's 20 years old. And I got a 2-0 or something on the 216.
That's correct.
That's not good. No alcohol, no marijuana, no illegal drugs. I want you going to AA at least 3 times a week. That scares me when that's the age. I'm just telling you, I'm not trying to be punitive here. I'm just telling you. AA 3 times a week in person. My court officer is going to hand you a form every time you go. You have to have the form signed. Every time you come to court, you have to bring the form with you. So no alcohol, no marijuana, no illegal drugs. You cannot leave the state, cannot violate a law. You must appear in court as directed. And you're going to AA, NA, either one, or any combination thereof, 3 times a week in person. And then I'll give you a new court date, and you're going to have to fill out a petition for a court-appointed lawyer. $1,000 personal bond. We're going to give you May the 7th, is it, Heather?
Yes, at 10:30.
At 10:30. Boy, we better bring our track shoes that day, huh? At 10:30 in the morning, all right? Anything else? All right, I wish you well. You're all set.
I would state to the court, request of the court, if the court makes a determination that he's gonna get appointed counsel, I would ask for an order of discovery.
Sure. Where do you work?
Johnny Pappas, painting industry,
How much do you make there?
around 1,000 a week.
Do you have any kids? You're not married. Where do you live? Who do you live with? You pay rent? Yeah, I don't think I can appoint you a lawyer. I really don't.
Well, I just wanted to find out,
No, I don't have a problem if you want to get a discovery order now. At least he can use it going forward, but I don't think somebody making 52,000 that's living at home with his parents with seemingly no bills. I can appoint a lawyer to on the basis of indigency.
was there one in the file already?
You mean a petition?
Discovery order.
No.
Okay, I'll take one.
Yeah, if you want to get it, I'll sign it and put it in here. But I think I'm pretty much going to have you hire your own lawyer, okay? If you want to fill out the petition, I'll look at it again, but I doubt I'm going to appoint you one. Okay, good luck to you. And go down the hall and get your notice. Joffrey, Francisco, Alamoto, Santana. This is 26T6477765 A and B.
And good morning, James Schlock, 30720. Is the head of Mr. Sims.
All right, Ms. Villarreal, your name again?
Yes, Your Honor. Evelyn Villarreal, certified court interpreter, C3822.
She's always so pleasant here, Mr.
Absolutely.
Huh? I mean, if I could spend my whole life around it in this building, around people that kind and considerate, she's very nice. She's already sworn to an oath. So, Mr. Santana, tell me your name, please.
Santana, dígame su nombre, por favor.
Yo Francisco Alamoto Santana.
Joffrey Francisco Alamocho Santana.
All right, so as I understand it, Mr. Schloff, your client will plead guilty to no operator's license on person. Well, first of all, he stands mute and waives formal reading, right? And now he's going to plead to no ops on person with the suspend to be dismissed.
Correct.
And then he's going to also plead responsible to using a handheld device while operating a motor vehicle. True?
Yes, it is. I
Yes.
explained to him his rights and penalties.
Is that what you want to do, sir?
¿Y eso es lo que usted quiere hacer, señor?
Sí.
Yes.
If you plead guilty to no operator's license on person, that is a misdemeanor. The possible penalties are up to 100 fines, 90 days jail, costs are all those. Do you understand that?
Sépase que usted se declara culpable de no tener licencia de su persona. Esto se considera un delito menor, con multas de máximo de $100, más $90 posible en la cárcel máximo, más costos de la corte. ¿Comprende ustedes?
Sí.
Yes.
Did you go over these rights on this advice of rights form with Ms. Villarreal?
¿Usted realizó estos derechos que están aquí en este formulario con la señora Villarreal? Yes.
Did she read them to you and did you understand them?
¿Y ella se los leyó a usted y usted los entendió?
Sí.
Yes.
If you plead guilty, you're giving up all of these rights and we are not going to have a trial of any kind. You understand that?
Y si usted se declara culpable, usted renuncia a todos estos derechos. Y usted no va a tener un juicio de ningún tipo. ¿Comprende usted eso?
Sí.
Yes.
All right.
Yeah.
And you understand that there could be potential immigration consequences as a result of this plea.
Y comprende usted que como resultado de esta declaración puede que usted tenga posibles consecuencias inmigratorias.
Sí.
Yes.
Do you still wish to plead guilty?
¿Y usted aún quiere proceder a declararse culpable? Yes.
To the charge no valid operator's license on person, how do you plead?
Así que al cargo de que usted no tenga su licencia de conducir válida contra usted, ¿cómo se declara usted? Guilty.
Were you operating a motor vehicle on March 3 of 26 at 10:55 in the morning on Fort near Van Horn and Trent?
Y dígame, ¿es cierto que usted iba manejando un vehículo motorizado el 3 de marzo del 2026 a las 10:55 de la mañana por cerca de la calle de Fort y Van Horn en la ciudad de Trenton? Sí. Yes.
Did you have a valid operator's license on your person?
En este momento, ¿todavía una licencia válida de conducir coches? No.
Are you on probation or parole?
Y en este momento tiene usted libertad condicional o libertad a prueba en esta forma. No.
Anybody force you to plead guilty?
¿Y alguien no ha forzado usted que se declare culpable?
No.
No.
And to the charge of using a handheld device while operating a motor vehicle, mobile device, how do you plead, responsible or not responsible?
Decía claro de que usted estaba manejando mientras tenía en su mano un dispositivo móvil. ¿Cómo se declara usted responsable o no responsable? Responsible.
All right. I'm going to accept your plea of guilt to no ops. I'm going to accept your plea of responsibility to using a handheld device while operating a motor vehicle, mobile device. And I'm going to dismiss on motion of the prosecutor the drive while suspended or unlicensed charge. I'm ready for sentence.
Así que acepto su declaración de culpable que no tenía una licencia de conducir en su persona. Acepto también su declaración de responsable al cargo que tenía un dispositivo en la mano, es decir, un teléfono, mientras iba manejando. Y debido a la moción de la fiscalía, desestimó el cargo original, estaba manejando sin licencia.
All right, anything you would like to say?
No.
How's its record? All right. 50 fines, 50 costs, 75 victim's rights fee, $50 justice assessment, $225
Muy bien, es de $50
or 30 days.
$50 en multa 50.
200 on the using a handheld device. Don't be doing that, please. I see people traveling all over the road that are doing that. 425 is your total. Can you pay that now?
¿Puede usted pagar $420 ahora? Yes.
You're all set. Ms. Villarreal, thank you so much. Thanks a lot, counsel. Good luck to you, young man. I wish you well. Thank you.
Your Honor, I'd like to mention to the court, I did have 2 other cases scheduled for 9:30. They don't appear to have come today.
Yeah, I was told that. I'll just issue warrants. If they show this late, they're gonna have a problem with me anyways.
Then the intruder.
Miss, were
Yeah.
they both with Judge McNally or do you have one with Judge Hessen too? I know we had one other one. Or were they both with Judge McNally?
Both with Judge McNally. I do have on another date that's coming up a case with
Oh.
McNally and Judge Hessen. Maybe that's.
Okay, I'm getting them confused.
What
Thank
city
you.
were those with? Do you remember?
I believe they were all Trenton.
Can you write up the warrants for me real quick, Mr. Bologna, while I finish this up, and then we'll do that motion? Yeah, there's apparently a couple where the defendant didn't show up that Ms. Villarreal was appointed on. They were supposed to be here at 9:30, so if you can write those up and send them in, I'll take care of that, and we'll get them going on that motion. Thank you so much.
Judge. I said in
Your
Harbor,
Honor.
they're waiting for me to get back there, so.
Nathaniel David Hayes, 25T643636. Where's Mr. Hayes at? Is he here? I don't know what happened here. Did Mr. Hayes not show up on today's date? You know, I just don't want to get in the habit of dismissing these unless there's a valid reason, somebody's in the hospital or what have you. When on review hearing dates, I'm going to just indicate the defendant failed to appear for show cause. I'm sorry, for review hearing, issue show cause regarding why conviction should not enter for failure to appear for review hearing date. I don't believe he ever was in the building. I think Mr. Bologna wrote this up and the defendant didn't show. So that's how I'm going to handle that one. All right. Do you have anything else for me?
Not quite, no.
I think you're done maybe, unless you were appointed on one of those others.
That I'm aware of.
Okay. Tell Mr. Will you do me a favor? Go tell Mr. Bologna not to worry about writing those up now. He can come now and he can write them up later. Thank you.
These all done?
They are, and I need a yellow pig. Okay, I'm good. All right. Okay. Your name? So counsel, are we adjourning this again?
That's what we're asking for, Judge. I've got video discovery. There's an issue with getting it to play. I can go into detail, but they sent it to a staff member of mine that needs to be sent directly to me because of the warnings from CJIS. Mr. Booth also has a probation matter that's up on May 13th. It's kind of debatable whether we need to resolve this case first or the probation violation that's alleged resulting from this charge. So if we could come back on May 7th, I think that would allow us to resolve both of those issues, Judge.
Okay, last adjournment, okay?
Understood.
I'm gonna just make a note, set for jury, if not resolved on that date, okay?
Okay, Judge.
What time do you have for me on May 7th, Heather?
9:45.
9:45, all right?
Great, thank you, Your Honor.
All right, anything else?
No, I don't think so.
Okay, have a good day. Good luck, sir. You can go down the hall and get your notices. Thank you. Priority Waste, 260-648-116.
Judge, Miss Trombley had to walk into another courtroom or
Fine,
courthouse
I'll go
to
on
go
to the
through.
next one. Ahmed, Ali,
In this courtroom, the judge carefully listened to every detail before reaching a decision. The court showed patience, fairness, and respect for both sides, while ensuring that accountability remained at the center of justice. The judge's words reflected the importance of responsibility, self-control, and respect for others. Rather than acting on emotion, the court relied on facts, evidence, and the rule of law. This case serves as a reminder that justice is not only about punishment, but also about protecting victims, encouraging accountability, and maintaining public trust. The courtroom once again demonstrated why fairness and law matter in society.
In this courtroom moment, the judge demonstrated exactly why fairness and accountability matter. Faced with a defendant who had missed court multiple times, the judge remained patient while carefully reviewing the record. Instead of rushing to judgment, he explained the seriousness of repeatedly ignoring court orders and gave the defendant an opportunity to speak. The judge's words were firm, but they reflected a commitment to responsibility and respect for the legal process. By holding people accountable while still listening to their circumstances, the judge showed professionalism, integrity, and dedication to justice. It was a powerful example of leadership from the bench,